Today, we are going to take a deep dive into the absolutely brilliant legal mind of Ruth Bader Ginsburg. We're going to explore the two really powerful and distinct acts of her career. First, as this master strategist, just dismantling discrimination, and then as the measured jurist shaping the law from inside the nation's highest court. Look, a lot of us know her as the Notorious RBG, right? A total cultural icon. But behind that celebrity was this razor-sharp legal architect. So the real question is, what was the actual strategy she used as a young lawyer that just fundamentally changed the whole landscape of American law? Okay, let's get into it. So, before she ever put on a judge's robe, Ginsburg was an advocate, and a truly brilliant one. She wasn't just arguing cases one by one, no. She was playing chess, always thinking multiple moves ahead, figuring out how to take apart an entire system of discrimination, piece by painstaking piece. To really understand her playbook, we have to start with the case of a guy named Charles Moritz. So here's the deal. Moritz was the only one taking care of his aging mom. But when he tried to claim a tax deduction for those caregiving expenses, he was denied. And the reason? The law at the time only allowed that deduction for women or for men who had been widowed or divorced. Because he'd never been married, he was just out of luck. Now this is where it gets really clever. This quote reveals the entire strategy. You have to ask yourself, why would a lawyer who's fighting for women's rights take the case of a man? Well, it was a stroke of absolute genius. Ginsburg knew her audience, a judiciary that was almost entirely male. Her goal was to make them see that these laws, the ones based on gender stereotypes, well, they weren't just hurting women, they were hurting men too. And that made this abstract idea of equality suddenly feel very personal and very real to the people in power. So, how did the government fight back? Well, their defense blew up in their face, spectacularly. To try and prove that this one tax law wasn't a big deal, they basically argued, hey, if you strike this down, you're going to have to look at all these other laws, hundreds of them, that also make distinctions based on sex. They thought it was a threat. Instead, they accidentally handed Ginsburg her roadmap. And that list the government provided, it became legendary. Seriously, it was known as Appendix E. And for Ginsburg and the ACLU's Women's Rights Project, it was pure gold. It was no longer a theory. It was a concrete hit list. This list literally became their playbook for the next decade, letting them go down the line, systematically targeting and challenging every single one of those discriminatory laws. Okay, so now let's shift gears. We're moving from the bold, fiery advocate to the careful jurist. Because when Ginsburg finally got on the bench, her approach changed. She wasn't leading a frontal assault anymore. She was working from inside the system, trying to build a lasting consensus. Her philosophy can really be boiled down to one word: gradualism. She had this core belief that for legal changes to actually stick, to become part of the very fabric of society, they had to be won through these careful, measured, persuasive steps. She worried that huge, sweeping, radical decisions could create a massive backlash that would end up undermining the very progress she wanted to achieve. And this quote from her just nails it. In her own words, a really effective judge doesn't just issue orders from on high. No, they engage in a kind of dialogue. They work to persuade their colleagues and, by extension, the public. For her, it was always, always persuasion over pontification. Now, to see this whole philosophy in action, let's look at one of the most unusual cases she ever decided. It's got a fisherman, a federal agent, and a bunch of undersized fish. I know, it sounds a little weird, but trust me, it's a perfect window into her pragmatic mind. All right, so here's the story. A fisherman, John Yates, gets caught with a bunch of red grouper that are too small. They're under the legal limit. A federal officer tells him, okay, keep those illegal fish separate. But instead, Yates tells his crew to just toss the fish back into the ocean, obviously trying to hide the evidence. Now here's the wild twist. The prosecutors didn't charge him under a fishing law. They've charged him under Sarbanes-Oxley, the huge corporate fraud law passed after the Enron scandal to stop executives from shedding documents. Their argument? The fish were a tangible object. This led to a truly bizarre legal question that went all the way to the Supreme Court. Is a fish a tangible object in the same way a financial record is, especially under a law that was written specifically to stop corporate evidence shredding? The entire case came down to how you read those two little words. And this case just perfectly illustrates two completely competing ways of looking at the law. On one side, you have Ginsburg, writing for the plurality, who took a pragmatic, common-sense approach. She said, you have to look at the context. Congress was worried about Enron, not fish. Applying it here would just be absurd. But on the other side, the dissent took a textualist approach. They argued, hey, the words on the page are all that matter. A fish is tangible. It's an object. End of story. The law applies. So Ginsburg's ruling basically said that a tangible object under this specific law had to be something used to record or preserve information, like a document or a hard drive. To apply it to a fish, she wrote, would cut the law loose from its financial fraud mooring. And then she also brought in the rule of lenity, which is a classic legal idea that says when a criminal law is unclear, you should lean in favor of the defendant, not against them. And this is a really crucial point, you can't just label her a gradualist and call it a day. She wasn't always cautious. In one huge area of the law, the Sixth Amendment right to a jury, she helped lead what was basically a revolution. She was a consistent key vote in a whole series of cases that said any fact that increases a criminal sentence has to be found by a jury, not just a judge. That completely changed how sentencing works across the country. So when we step back and look at her entire career, you see these two threads, the bold advocate and the careful jurist. And you see how they weave together to form this incredibly complex and powerful legacy. What her life's work really shows us is this powerful combination. On the one hand, you have the bold advocate who looked at the whole system and literally created the playbook to tear down discrimination. And on the other, you have the cautious jurist who knew that to make that change actually last, you had to execute that plan carefully, persuasively, one step at a time. And honestly, this quote says it all. It's the perfect summary of her entire philosophy, both in life and in the law. You've got the passion of the advocate right there. Fight for the things you care about. But you also have the wisdom of the jurist. Do it in a way that will lead others to join you. And that really leaves us with the central question that her legacy poses, one that's just as relevant today as it ever was. When it comes to making a better world, what's the better path? Is it radical, immediate disruption? Or is it the slow, steady, careful work of building a consensus that will actually last?